Portfolio Recovery Associates versus Tyler Brown. Number 4, Midland Credit versus Christina Barrett. 5, Department Stores versus Nadine Smith. 6, Jamar Hill versus Apex Holding. 7, Capital One versus Dynas Amir.
This is plaintiff. No need to take the case down, please.
Okay. Bank of America versus Rodney Black. Ohio Security versus Impact Quality Cleaning.
Scott Shipley in here for Ohio Security Insurance Company.
Do you want this taken down for the record?
No, ma'am.
Clive Richards versus Atlantic QOZ Fund.
Yes,
Do you want this taken down for the record,
yes,
Mr. Richards? Mr. Richards, are you representing yourself?
yes.
Let me explain something very quickly to you. The court reporting, there's a service fee for $43.31 per hour. It will be due at the end of the hearing. I will take your email address and send an invoice to you through Square.
I
do you still
cancel
wish-
it then. I
Pardon?
would cancel it. I can't take that chance with you.
Nope.
And
No
this is counsel for the defendant, no takedown needed.
Okay. National Collegiate Fund versus Tiffany Parks. Number 12, America Smart versus Bohas. Number 13, National Collegiate versus Laura Gaynor. Number 14, National Collegiate versus, I'm sorry, I just said that one. There's 2 positions. I'm sorry, it is a second one. National Collegiate versus Laura Gaynor, second one. The last one I have is Spring Valley Homes versus Armida Didovart.
Plaintiff
Yeah.
does not.
I am number 12, ma'am.
Number 12, okay.
Yes, ma'am.
Um,
This is,
Number 12, Amerismart versus Bohas,
Yes, number 12.
okay. Would you like this taken down for the record?
Excuse me?
Would you like this taken down for the record? That
No.
means, no,
I
that's a
don't
court
know.
reported being present, taken down word for word, everything you say.
No,
Okay. And I apologize, Ms. Taylor, you said you do not need a reporter?
plaintiff request one.
Okay. Thank you, Judge.
This is, ma'am, this is
Yeah.
number 14. I'm counsel for the defense,
Mhm.
Karen Young.
Yeah.
We may seek, if we have a hearing, we may ask that it be reported under the rule.
No problem. And your name again? I just see Karen.
That's fine. Karen Young, Young.
Thank you. Okay, well, I'll hang around once the judge gets started, and I'll wait till your case is called, Ms. Young, to see if you need me or not. No
Thank
problem.
you. And what is your name again?
My name's Octavia Winfrey.
Octavia.
Yes,
Thank you very much, Octavia.
you're
Ms.
welcome.
Winfrey, I see your name now. Thank you.
No problem. Hey, Mr. Stevens, do you
Good
want your
morning.
cases taken down?
Yes, I'm here on America Real Estate versus Sanjas LLC and Ken Demir.
America Smart?
Yeah, America Smart versus Sanjas LLC.
Okay, I see it. That's number 12.
And yes, I would like that taken down, Ms. Winfrey.
Okay, and do you have a second one?
No,
The first one, Commerce Industry versus Nails, the very first one?
I'm not familiar with that one. I can check
Okay.
with my office. Who's the attorney listed on that?
Richard Howe.
Okay.
I see it's your office. That's why I asked.
Commerce and Industry versus
Nails, NAOS, on-site
NA.
staffing.
OS. Do you have a civil action number?
Yes, 20 EV 007367.
Well, thank you for that. I'm going to call my office.
No problem. Thank you. It's first up as well.
All right.
Thank you, Judge Richardson.
Thank you, Ms. Winfrey. Good morning, everyone. Mr. Stevens, that case number one that Ms. Winfrey referenced, the attorney did contact our office and that has been settled.
All right,
So
well,
that
very
is
good.
off the calendar for this morning.
Thank you. I was not familiar with that one, so thank you very much, Your Honor.
All right. I'm going to go through the positions and see what we have ready to resolve. Position 2, which is Durham versus Vargas, that has been resolved. All right, position 3, Portfolio Recovery Associates versus Brown. Do we have the parties here on that? Right. Position 4, Midland Credit Management versus Christina Barrett. We have the parties here on that one. All right, no response. Position 5, Department Stores National Bank versus Smith. That one was resolved. Position 6, Jamera Hill versus VR Apex Holdings. We have parties here on that one. All right, no response there. Position 7, Capital One Bank versus Dynastamir.
Good morning, Your Honor. James Nadler on behalf of Capital One Bank.
Do we have Dynastamir? All right. Well, this was here for a call for trial. Ms. Amir is not here. Are you ready to present evidence today, counsel?
Yes, Your Honor, we are. I have a witness. Ms. Brown is here today, too.
All right, I'm going to ask you to stand by. I'm going to go through the rest of the calendar and then we'll get your evidence and we'll get your case resolved today.
Thank you, Your Honor.
All right, position 8, Bank of America versus Rodney Black.
Skip Breeden for the plaintiff, Your Honor.
We have Mr. Black here. All right, that one also I have is ready for trial. Counsel, are you ready to present evidence?
Your Honor, it's liquidated damages, but we also have filed a business records affidavit. So yes, we are prepared.
I will come back to you, see if we've see what we've got in the record. All right, position 9, Ohio Security Insurance Company versus Impact Quality Cleaning Services.
Morning, Your Honor. My name is Scott Shipley, in for Plaintiff, Ohio Security Insurance Company.
Do you have anybody here for Impact Quality Cleaning Services? All right, Mr. Shipley, I saw there was a motion for default judgment. I also saw that the complaint was verified as to the damages. You did submit a proposed order for final judgment. Is that order still correct?
Yes, Your Honor, it is.
All right, I'm going to sign that order. I've signed that order and we will get it entered.
Thank you, Your Honor. May I be excused?
Yes, you may be excused.
Yes. Thank you.
Position 10, Clive Richards versus Atlantic QOZ Fund.
Here,
And Robert Dukes on behalf of Atlantic QOZ Fund, Your Honor.
All right. All right, I will come back to you both. All right, position 11, National Collegiate Student Loan Trust versus Tiffany Parks. All right, that's dismissed. All right, position 12,
Yes, sir.
America Smart versus Vogus and Candemir. We have
Yes,
both
that's
parties.
number
morning.
12. Yes.
Good morning, Your
Number-
Honor.
Good morning.
Scott
All
Stevens
right,
For the plaintiff on that case.
all right. Got both parties
We have
here.
a motion to strike the pro se answer of the LLC, Your Honor. And we also have a motion for discovery sanctions pending against the defendant, Mr. Demir.
All right, we will come back to that one. All right, position 13 and 14, National Collegiate Student Loan Trust versus Gaynor. National Collegiate Student Loan Trust versus Gaynor. All right,
Ms. Young, that's the case you inquired about?
No, the case that I'm involved in is Spring Valley versus Didiver.
Okay, my apologies.
all right, so let's go to that one, Spring Valley versus Didivaret.
Good morning, Judge Beth Taylor here for plaintiff.
Your Honor, Karen Young here for Armida and Pejman Didiver.
All right.
And the Didavars are here.
All right, and I think we have a motion for default judgment and a motion to open default on that.
Yes, Your Honor.
All right.
Yes, and
Oh,
we have been talking for the past couple days after the holidays. I don't know if Your Honor would be inclined to put us in a breakout room so we could continue those discussions before hearing those motions.
I'm happy to put you in a breakout room. Let me go ahead.
And then, Your Honor, just so you know, I have my associate Griffin Bell, and then I have two witnesses or clients on as well. Yolanda Dean and Susan Hayes would also be in that breakout room.
Dean, Hayes, Taylor, and counsel for, and the Didiver.
Didivar Young, and then also my associate Griffin Bell.
Your Honor, I'm sorry. Pardon me. This is Ms. Young. We also have some folks ready if, you know, them that can go in a breakout room as needed.
All right, who else? Who do you have also?
We have Shahab Didivar. We have both of the defendants, Armida and Pejman, as well as Mr. Didivar. Remind me who the other young man is.
Mr. Louis Jackman.
Thank you.
All right, let me see if I've got everybody. We've got most of the people here. All right, so I've got Armida Didivar. I've got Beth Taylor.
S. Didavar.
S. Didivar. Griffin Bell. Griffin. Wanda. All right, let me try and see if I can get everybody.
I'm
Thank
sorry.
you.
You also get Miss Susan Hayes.
Please, all right. I think I've invited everyone to join. Armita Didipar has not joined, and Karen has not joined.
Okay.
I have Armita Didavar on my screen. I've invited you to join the breakout room, but you have not responded. If you want to be included, you have to let me know. Right now, you are muted and your camera is off. All right. No response. We will move on. Let's go to our uncontested cases first. Let's start with Capital One versus Dynastamere.
Good morning again, Your Honor. James Nadler on behalf of Capital One. We are here today, obviously, for trial on this case. The defendant is not here today, so I would ask the court to strike his answer, strike his counterclaim, and I'll move forward with regard to our case in chief. If the court's inclined, the damages are liquidated, but I'll be glad to prove up the damages if the court would like.
Yeah, it wasn't clear to me from looking at the documents that they are. I've got a ton of statements. I don't know what they add up to. I'm not a math person.
I can walk you through them. It'll take me with the witness. I can do it in a matter of 3 or 4 minutes.
All right, let's go ahead with that.
Great, thank you. You do have the documents in front of you, though. Is that correct?
Yes, I do.
Great. If Ms. Brown could unmute and turn her camera on, we'll be ready to get started.
Hi, everyone.
Hi there.
Good morning, Ms. Brown.
Good morning, Judge.
Ms. Brown, you raise your right hand, please. You swear that the testimony you give here is true and correct under penalty of perjury?
Yes.
All right.
Okay, Ms. Brown, can you state your full name for the court, please?
Yes, it is Sheree Brown, S-H-E-R-E. Last name is Brown with an E, B-R-O-W-N-E.
Okay, and what is your business address?
It is 4851 Cox Road, Glen Avenue, Virginia, 23060 is the zip code.
And your employer?
Capital One.
Okay, and what business is Capital One in?
It is a National Banking Association.
Okay, and as part of being a National Bank Association, do they extend credit to individuals?
Yes, they do.
Okay, and what is your position at Capital One?
I am a litigation specialist.
Can you tell the court what your duties are?
I basically research and investigate charged off accounts, and when necessary, I provide testimony.
Okay, and are you familiar and trained in the manner and methods of Capital One when they create business records?
Yes, I am.
Okay, and what is the manner and methods which Capital One employs?
Basically, whenever a transaction, a defendant makes a transaction, the transaction is recorded electronically. Those electronic records are provided to the defendant on a monthly basis.
Okay, and are those kept in the ordinary course of business?
Yes, they are.
Okay, and do you have personal knowledge of this fact?
Yes, I do.
Okay. And are you familiar with the account of Dynastamere, the defendant in this case?
Yes, I am.
Okay. Did Capital One extend credit to Dynastamere?
Yes.
Okay. And what type of credit was extended?
This was a personal credit card that was extended to the defendant.
Okay. And when was the account open?
In September of 2018.
Okay. I'm going to, Your Honor, I believe you have copies of this. I'm going to direct Ms. Brown to the trial exhibits. Do you want me to share my screen? Is that easier for you, Your Honor?
You don't need to.
Okay, great. then I'm going to just walk through some of these documents. Okay. Ms. Brown, I'm showing you Group Exhibit B, which are the credit card statements. Can you tell the court when this account was opened?
This account was opened in September 2018.
Okay. And what's the account number, or the last 4 digits of the account number?
6825.
Okay. And where were these accounts sent, the statement sent?
Initially, the account statements were mailed to the defendant. A month after the account was opened, the defendant elected to receive these statements electronically.
Okay. And these account statements are in the name of the defendant, Dinest Amir, is that correct?
That is correct.
Okay. And without going through each and every statement, I'm going to direct you to, I guess the easiest thing for me to do is to go to the charge-off statement. If you can go to, I believe it would be page 60 in the trial exhibits.
I'm there.
Okay. And if you can tell the court what you are looking at.
This is the last statement that was sent to the defendant. This is typically called the charge-off statement. And it has an outstanding balance of $23,305.77.
Okay, can you tell the court exactly what a charge-off statement is?
Hold on, before you go there, can you show me that one? My pages,
Sure.
I don't think my pages are, or at least I can't find the number on it.
Okay, you have disabled my screen sharing.
All right, let me enable it.
And a copy of this charge-off statement should be attached to the actual complaint itself, though.
All right, that I don't have the complaint directly in front of me.
And I will go ahead and. Your Honor, are you able to see it now?
I see it now, yes.
Great. Okay, so on page 60 of the group exhibit, Ms. Brown, what exactly is this document again?
This is the charge-off statement.
Okay, and what's the balance of this?
It is $23,305.77.
And the name on the statement is?
Dinest Amir.
Okay. And this has the same account number that you testified to earlier?
Yes, it does.
Okay. Now, can you tell the court what a charge-off statement is?
The charge-off statement is the last statement that's sent to the defendant before the account is officially closed.
Okay. Now, does Mr. Amir still owe the charge-off amount?
Yes, he does.
Okay. Has there been any payments made since the charge-off?
No, there are none.
Okay. And what is the amount that you are seeking here today?
The amount on the charge-off statement with an outstanding balance of $23,305.77.
Okay. Are you also asking the court to award you court costs?
Yes.
Okay. Your Honor, I don't have any more questions.
All right, you're entitled to a judgment in that amount, and including interest and court costs. Counsel, if you wouldn't mind submitting a proposed judgment to Mr. Townsend. I don't.
That's great, Your Honor.
have one, but let me know if I'm mistaken, and there is one in the file.
No, I haven't submitted one yet because it was contested. Your Honor, I'll be glad to submit it. Also in the order, if the court's inclined, I move to strike the answer and counterclaim.
That request is granted. Answer and counterclaim are stricken.
Thank you, Your Honor, and thank you very much, Ms. Brown.
Thank you.
Your Honor, this is my last case before you today. May I be excused?
You may be excused. Thank you, counsel.
Thank you for your time, Your Honor.
May I be excused as well, Your Honor?
Yes, you may. Thank you for your appearance here.
Thank you, Judge.
All right. All right, let's go to position 8, Bank of America versus Black.
Skip reading here for plaintiff.
All right. Well, this one you said damages were liquidated.
Yes, Your Honor. So we're moving to strike the answer, enter default. For purposes of determining damages, I'd like to direct the court to our complaint, where we are seeking to recover a credit card debt of $19,891.95 plus court costs. On page 9 of that document, you will find an affidavit from a custodian of records from Bank of America testifying that that's the balance due, and attached to that is a charge-off statement showing that same balance due.
All right, just give me one moment to pull that record up. It may take a minute for me to load up my case management screen. Just bear with me. All right. I see the affidavit and the charge-off statement. So $19,891.95. Is that correct?
That is correct, Your Honor.
All right.
We are requesting attorney's fees in the amount of $324.13.
And that is calculated under 13-111.
Oh, attorney's fees, Your Honor, not, I'm sorry. I misspoke. I meant court costs.
Court costs, all right. All right. Filed the judgment in the amount requested, the 19,000 and change plus court costs.
Thank you, Your Honor.
Did you submit a proposed judgment or if you have?
I have not because it's contested, but I'll be happy to do so today.
All right, let's send it on to Mr. Townsend and we will get the judgment entered.
Thank you, Your Honor. May I be excused?
Yes, you may be excused.
Thank you. Have a good day.
Let's go to America's Mart versus Voges and Candemire.
Yes, sir.
Good morning, Your Honor.
Good morning.
All right, so y'all have been before me.
Yes,
And,
couple months ago. Yes, sir.
and you know, I think the last discussion we had, Mr. Demir, was that they were going to be entitled to a judgment against you. And it was up to them as to how they were going to prove it. And that we set it down for a future hearing to consider damages. As I understand it, the corporation, you answered on behalf of the corporation. The corporation didn't have an attorney. You're
Me?
yes, and you're ordered to either to get an attorney or the answer would be struck. It does not appear that there's been any attorney to enter an appearance So the corporation, the answer is stricken.
Last time I came, sir, like 4 months ago, I came and we did speak with you like 10 minutes. And then after that, I don't know what happened. They said, they will let me go. And they said, yeah, they will let me know about this. And I got this letter. So that's why I came in.
Well,
They sent me the letter.
well, where we are, Mr. Demir, is
Yes,
that
sir.
they're entitled, based on failure to answer, they're entitled to a judgment, and they're entitled to a judgment against you personally and against the company. And you've explained to me all of your circumstances as to why you can't pay, but regardless of whether you can pay or not, they're entitled to a judgment for some amount. And so we're here today to talk about what that amount is.
Me?
Let me go to the plaintiff's counsel.
Yes, Your Honor. My understanding is that the court entered an order compelling discovery responses back in June. We have the pending motion to strike answer as a discovery sanction and for default judgment, which I believe the court has stated is inclined to grant. The damages are liquidated, so we would request the court to enter judgment based upon the amounts pled for. And the same would apply, Your Honor, to our motion to strike the pro se answer of the LLC. The court had granted an order requiring the LLC to retain counsel within 30 days, which the LLC has failed to do. So we believe the damages are liquidated and would request that judgment be entered accordingly. And I believe we've submitted proposed orders on those, Your Honor.
All right, let me just make sure that we are liquidated here.
I don't know what all that means, sir. I'll be honest with you. I received this letter and I got the Zoom meeting. And last time they said me they come to court. I came to court like 4 months ago.
All right. Well, Mr. Stevens.
Yes, Your Honor.
Is it the contention that no rent was ever paid or some rent was paid and the amount requested is the amount that was unpaid? I do not see an affidavit or anything that clearly indicates to me the amount that's currently due and owing. So help me with this.
I don't have the complaint in front of me, Your Honor. I had to log off of my system to do the Zoom call. And but our position is the damages are liquidated. And if the court thinks differently, then we will need to get a witness and have that set up for a hearing on the damages issue once the court issues the order striking the two answers.
Yeah, typically, I see an account statement. I do not see a verification. Usually if I'm going to grant a judgment, I want somebody from the client under oath as to what amount is due. And that can be by affidavit or it can be in person. So if you want to have your client submit an affidavit as to what's due and owing, I will definitely consider that.
All right, Your Honor, may we have 30 days to submit that affidavit?
Yes, you may have 30 days.
All right, very good.
All right, Mr. Demir.
Yes, sir.
You've got some questions, so I'm going to try to answer your question.
I'll be honest with you, I don't understand everything because I was paying when I was in this building. In the after I was struggling couple months, I was behind for my couple months of my rent, and they sent me the letter after the COVID-19 pandemic start, and they sent me the letter. They said you have to leave the building as immediate. Basically they tell me that I have to leave the premises because after the COVID, like a mid March, they told me that I have to leave the premises immediately. So that's what I did. I was behind only for the couple months for my rent because that time ago I was struggling because the February was nobody. In January, February was low. In mid of March, they sent me the email and they said you have to leave the premises immediately, and that's what I did. Hello.
So are you claiming so you're claiming that you don't, because I've already struck your answer. You still have the right to dispute damages if you want to dispute damages. Are you claiming that there's some portion of the rent that you don't owe?
Yes, because I don't absolutely, because if I was struggling all that time, and after the COVID-19 started, and they sent me the email, and they said you have to leave the premises immediately. Basically, they just kicked me out from the building. So that's what I did. I didn't even argue with them about this, and I just I just left the premises, and they left it. And after that, I've been doing the Uber driving, all this. I have 2 kids, and I have $10 in my bank account. I don't know what they want from me, but
Yes,
I have.
you've explained to me already about your financial circumstances. I can't take your financial circumstances.
Yes, no, sir, absolutely. It's they told me that I have to leave the premises immediately in that time, like mid-March, when the pandemic.
I understand that, sir. So it sounds like you're disputing the amount that's due as unpaid rent. Mr. Stevens, I think I'm going to have a hearing on the damages portion of it.
All right, well, that's fine, Your Honor, if you can reset that. And do you have a date certain for the reset?
I do not have a date certain for the reset. We'll likely need to do it in person.
All right.
I suspect I'll have to have Mr. Demir in front of me when we do this.
All right, well, that's very good, Your Honor. Shall we submit proposed orders striking the 2 answers?
Yes, please submit those to Mr. Townsend. We'll get the order striking the answers, and we'll set for the hearing on damages. And Mr. Demir, you'll get to, at that hearing, you'll get to dispute the amounts that they say are due, and you'll get to ask any questions of the plaintiff's witness that you want to ask, and present any evidence you want to present on the issue of damages.
Okay, yes, sir.
All right.
Yes, sir.
All right, thank you.
Very
Mr.
good,
Demir.
Your Honor.
Thank you, Mr. Stevens. Y'all may be excused.
Okay, have a good day.
You too. All right.
Yes, sir. I stay, sir.
You can,
I stay.
you're free to go, sir.
Okay,
You'll get notice for the next hearing.
I will get the email again. I will get the mail again if something. Yes, sir.
Yes.
Okay. Yes, sir. Thank you. Yes, sir.
Bye-bye.
You have a nice day. I'll leave. Thank you, sir.
All right.
Yes, sir.
All right, let's go to Clive Richards versus Atlantic QOZ Fund.
Yes, Your Honor.
This is an eviction appeal. As I understand the record, Atlanta QOZ Fund filed a dispossessory. Mr. Richards contested that dispossessory, and an order granting dispossessory was entered, and Mr. Richards filed an appeal from that order.
That is correct, Your Honor.
All right.
And Your Honor, this is Attorney Robert Dukes with QOZ Fund. My witness here is Alan And Your Honor, very briefly, the defendant filed a motion for an injunction that we're asking the court to strike. And very briefly, Your Honor, it's just a procedural issue, as you know, probably, and I know, which is when you appeal a case from magistrate court, state court or superior court only has the power in terms of what magistrate court had at the time of the initial filing, because you're technically in an appellate review phase. So money damages, we could argue all day, but one, state court doesn't have the power to do any type of injunction. Two, based on the fact that this is an appeal, it's not possible to do an injunction at this time, Your Honor. And Your Honor, I'm basing that off of the case of Gals versus the Sakis. And Your Honor, that's Georgia Court of Appeals 262, Georgia at 483. It's a 2003 case. But as you're probably aware already, because it's an appeal case, Mr. Richards would have to file a motion and file a new case for any type of injunction or equity relief in Superior Court, which has exclusive jurisdiction.
Yeah, Mr. Richard, you're in the wrong court for an injunction. You'd have to file a separate claim for an injunction in Superior Court. In state court, I don't have the authority to enter any kind of injunction, so I can't even speak to the merits of your claim, whether you got a good claim for an injunction or not. I can't even address the issue. I can only address the issue as to whether or not Atlanta QOZ Fund is entitled to evict you or not.
Well, all right, we're going to speak on that one right there, Your Honor, for now. So what had happened is that during the time with the pandemic is that I did have a business, but certain things went wrong because of certain circumstance. So when I come to the landlord, I try to talk to the landlord to try to pay them money, little by little until my business therefore he wouldn't accept no money. And when he was in court, I did make a payment before I went to court. And what he did, he went and he blocked it from me to make another payment. So when I went to court, the judge asked us to go inside of a conference room and, discuss it to work it out. Whatever I was trying to work with him, he didn't want that kind of money. I guess he wanted it for a month. So I asked the judge, I said, can I pay him this part of the money? They wouldn't agree. So what happened is that I asked the judge, can he submit a document stating that if the property is covered under the CARE Act? The judge told me they didn't have nothing to do with that. So he wouldn't allow it. So I appealed the case so that the judge can see that the state court could see that I asked for that. I even sent a letter to them, both the attorney and to the property owner, asking for them to submit some letter saying that if it's like a property, cover property, whoever might live there, as Section 8 or support is paying rent there, stating a certain thing that was going on in the CARE Act. Now, even though with the CARE Act, it stated that on August 26, 2021, I guess it stated that it's over with whatever, but I guess the Supreme Court ruled that it let it be allowed for certain people. So because even right here, Your Honor, if you got the paperwork, you could see where I was stating something was from the court. I was citing a case. Give me 1 second, I was trying to find it.
Mr. Richard, my understanding is that you are contending that because of the moratorium, the eviction moratorium, that they were not entitled to dispossess you. Is that right?
Yeah. Well, to file the claim at that time, I was also trying to discuss that too, to file a claim, because during that time, even with that, I guess it stated in the Supreme Court saying that, I could make certain type of payment if I cannot afford to make the payment, things like that. But for some reason, he don't even want to collect no payment because I guess he figure it's not enough. He don't even want to collect no payment at all. He keep blocking me. He even tried to get me set up on a program for them to make the payment, but at the same time, he was still trying to charge me $400 or $500. And I said, well, I got this amount. Can I pay this percentage since they already gonna be paying for me?
So let me ask you this question. So you signed a lease when you for this apartment, is that right?
I signed a lease after that lease. I used to work for the landlord. I used to watch property for him. So the reason why that lease was signed, Your Honor, is that during the pandemic, I was trying to get like assistance, and they were asking for like a lease. So since he was so anxious for money, that's when that lease was done, so that I could submit to those people for them to be able to pay, but they didn't come to with their part.
So what agreement, so the lease says it ends on December 31st, 2020. So why do you contend you still have the right to be there after December 2020? What's the basis for you being allowed to stay in after the lease ends?
Okay. All right, Your Honor. I want to go to this where I could read it out to you. Hold on. Okay, Your Honor, it's stated in the Alabama Association of Realty, ETAL, versus Department of Health and Human Services, ETAL. It said to be protected from eviction, a tenant must reside in a covered area and attest that he or she has used best effort to obtain all available governmental assistance for rent or housing. One, has used best effort to obtain all available governmental assistance for rent or housing. Two, satisfies certain income requirement. Three, is unable to pay rent. Hold on. He said, household knowledge, income loss of compensable hours of work or wages. Then he goes down to number 5 where he said, and if has no other available housing options. So these things was coming from like the Supreme Court during those times, during the pandemic, whatever. So this is what I was asking the court.
So this was an issue that came up during the pandemic, during the eviction moratorium. Is that right?
Yes, but it also stated in the I guess it also stated that in the Supreme Court they passed some type of ruling to where it stated in here that certain people will be covered. So therefore, what do you mean by that? Let's say if this place where I'm at, if they are covered by like let's say they have a Section 8 person living in the property paying rent, right? If they have that type of person in there paying rent, that means they are covered. And I asked them, can you submit that document to prove whether you are covered or not? And they have not submitted it.
Okay, I get what you're arguing, but it does. But as I read those provisions, it does not force a landlord to keep you in the property after your lease term has expired. And what it appears to me from the documents I see is that your lease term has long since expired. Over a year ago, the eviction moratorium has been ended because it could not be extended by order of the Supreme Court. And so it appears that you are staying there without the landlord's permission and without legal authority.
Your Honor, I try to pay this loan. Why would he block it from me making payment in the lower court? Why would he go?
I understand what you tried to do before, but I'm talking about as of today.
Yes.
As we stand here today, your lease has expired. There is no eviction moratorium, and they have no obligation, no legal obligation to keep you as a tenant, regardless of whether you want to pay or not.
But
And
why would they want to evict me
authority
then?
that allows me to force them to keep you.
So, Your Honor, why would they try to evict me at that time then, during that time? During the pandemic?
I'm not addressing what happened at that time. Clearly, they did not succeed in evicting you. Otherwise, we wouldn't be here today. But on the appeal, I have to consider the circumstances as they stand today. And as of today, I don't see a reason, a legal reason for you to be there. I think in the record, you've shown you have some difficult circumstances. You have financial circumstances, you have health circumstances. I understand that you're receiving some assistance. I understand those circumstances, but unfortunately, those circumstances don't allow me to force a landlord to keep you in there after the term is expired if they don't want you in there. Certainly they could choose to keep you in there if they wanted to, but I can't force them to keep you absent some other legal authority.
So, Your Honor, let me ask you a question. When that lease expired, right? Didn't it expire during the pandemic then?
It did, yes.
So therefore, if it expired in the pandemic during that time, then in that case, then I have the right. I could see if it would have expired, like after August, something like September, whatever. I could see if it expired this time, whatever it is, but it will expire during that time, and during that time, there was certain covered. And during that time, I was trying to talk to the landlord to state these payment, even though during the pandemic, I was asking the landlord to state these payment to give me time to go and, get up on my feet since we're going through this pandemic process thing. So that's the time when they expire, and it's like he ignored what was going on with the law, or ignore what was going on with what the court was stated, and just allow it to expire and just keep me from paying rent. He the one who stated wouldn't take the money. Whatever I was trying to pay them, he the one who decided not to take the money. So, Your Honor, if you rule in certain way, Your Honor, I just would have to take it to the Court of Appeal, because what I'm saying is that they would see the rights that I have in my favor.
And Your Honor, two things briefly.
Let me hear from you. Go ahead.
And I can allow Alan Seduris here to testify, but Your Honor, we're not seeking a money judgment in this case. I submitted the defendant's evidence, and I can have Alan testify about the ledger, but I only submitted the ledger, Your Honor, for the appeal provision that haven't paid rent into the registry of court. As the court is probably aware, 44-7 OCGA 44-7-56 requires that rent be paid into court upon an appeal. Mr. Richards technically has already had the benefit because my client didn't seek rent, and they did not seek that any money was paid into court while this appeal was pending. That he hasn't paid it in court.
I tried to pay it in court.
All right, Mr. Richards, he did not interrupt you.
Okay, I'm sorry.
But Your Honor, I was just trying to say, no money's been paid. This case isn't about money. It is just, as you stated earlier, Your Honor, about non-renewal, lease termination. The lease has expired. It's a function of time, nothing else. Your Honor, we would just offer testimony through Mr. Surdis about the actual lease and the amount that we're seeking if the court were to rule in our favor in case there is an appeal filed by the defendant.
If there is an appeal filed, there will have to be money paid into the court registry during the pendency of the appeal. So yes, I will hear that testimony.
Yes, Your Honor. So what happened when I tried to file the appeal, because I even put it in the record and I even sent it to you. When I tried to file the appeal, I have went to the because the judge who passed that ruling, he make a statement and he said no money. because I sent it to you, Your Honor. So what I did, I wasn't quite accepting it, so I went to the clerk. And when I went to the clerk to make payment, during that time, Your Honor, is that I got some money from the government to do for my business. So I went to the clerk to pay $3,000 there. And the clerk told me she couldn't accept no money. She told me because she said there ain't no, what you call it? She said the judge did not allow you to pay no money. The landlord just trying to get rid of me. I don't know for it. Then, Your Honor, right here, it stated this, right? It stated this. This is another law right here, right? He said this is in the city law. He said Section 9494, unlawful practice in selling or renting dwelling, right? He says shall be unlawful to refuse to sell or rent after the making of a bona fide offer or refuse to negotiate. The landlord did refuse to negotiate with me, right? Then he go down to the bottom. He said, I refuse to consider any source of income. This is going on. This is a law in the city of Atlanta now. So with this law right here in the city of Atlanta, the landlord have to accept it. That's the law right there.
All right, so Mr. Dukes, I'm going to let you offer your testimony as to the rental amount that should
Yes,
be
Your Honor.
paid to court if there is an appeal.
Yes, Your Honor. Thank you, Your Honor. Your Honor, I have Alan Sturgis here. Alan, please state your name for the court.
It's Alan Saritas.
And Mr. Sturgis, what is your connection to Atlanta QOZ?
Hold on, a second. Sir, let me get you under oath. If you would raise your right hand.
Sorry, Your Honor.
You swear that the testimony you give today is the whole truth under penalty of perjury?
Yes, Your Honor.
All right, go ahead.
All right. Thank you, Your Honor. My apologies. Please state your name for the court.
It's Alan Saritas.
What is your position with Atlanta QOZ Fund LLC?
I'm the owner of Atlanta QOZ.
Okay. And are you familiar with Mr. Clive Richards?
Yes, I am.
All right. How much is monthly rent at the property that he rents?
$800.
Okay. In your ledger, you reflect $600. Can you please explain to the court why that is?
It's $600 because Clive was doing some work around the property as like just keeping an eye and reporting to me if there's any suspicious people. So I kind of gave him a little bit of a discount. So I was charging him $600.
All right. So you were charging him $600. So you essentially were giving him a $200 credit
$200. Yes, credit.
monthly. Okay. All right. And so would you be seeking, is he still employed with you? Is he still watching the property on your behalf?
No, that ended over a year ago, well over a year ago, beyond a year ago.
All right. So in the event of an appeal, would you seek at minimum $800 paid into the registry of the court?
Yes.
And would you be seeking back rent from the time that the appeal was filed?
Yes.
And just to clarify, he's been in the property this whole time, correct?
That is correct.
To the best of your knowledge.
Yes.
All right. So what total are you seeking today?
So
in terms of rental payment into the court pending an appeal.
Okay, so if we do calendar year 2021, that would be $800 a month times 12, which would be $9,600. And then January 2022 would be $800. And then I'll just go with the previous balance up to 12/31/2020, which would be $900.
So what's the total amount that you would ask the court?
Okay, I would ask the court for $12,400.
$12,400. And you're saying that would be from the time period of December 2020 through January 2022.
Correct.
And again, no additional fees and stuff. You're just asking for rent only.
Correct.
Of $800. And you ask for any future rent payments of $800, correct? Per the lease.
Going forward, correct.
Your Honor, no additional questions at this time for the witness.
All right, so I'm going to find that you're entitled to a writ of possession.
Your Honor.
In the event of an appeal, rent shall be paid into the court in the amount of I'm going to enter a judgment for the back rent. And I'm only going to require him to submit $800 per month going forward if he chooses an appeal.
Your Honor, can I say something, Your Honor?
Yes, you may.
All right. What they're saying, whatever it is, right, is that even if I choose for P, right? Sorry. Even if I choose for P, Your Honor, is that why they cannot submit that document stating that they are a covered property. So since you don't want to accept that, then what it is that with this rules that coming from the Supreme Court, the Supreme Court make the statement saying that the person can pay what they can afford to pay.
Yeah, I'm not persuaded by the authority that you have given me, so I'm ruling against you on that issue. So you'll have the statutory time to appeal. I would check the law on that. It may only be 7 days to appeal from the time that I enter this judgment. And if you want to appeal, you'll have to deposit into the registry of the court $800 and then $800 for every month thereafter that the appeal is pending.
Well, I mean, Your Honor, is that whatever I'm trying to say is that I'm just going by what the
I've heard your, Mr. Richards, I've heard your argument. I don't agree with it. You have a right to an appeal and you have a right to preserve the status during the pendency of the appeal, but that is my judgment. All right, Mr. Duke, if you would submit a proposed judgment to
Yes,
Mr.
Your Honor.
Townsend,
Oh, yeah.
that will start the clock. That will start the clock ticking.
Your Honor, but can I ask a question? Can I
Yes,
ask a question? Why they can't submit? I'm asking you this question, right? Why they can't submit the document? I have a right for
Richard, I've already ruled.
Your Honor, why they can't submit the document? Why they can't submit the document stated that they
Mr.
are a
Richard,
covered property?
You can address that to the Court of Appeals if you decide to appeal. I have ruled.
I can pay what I can pay in the registry. I could pay what I can pay, but I got to appeal this because you're not letting them submit the document that's needed. But I will pay what I can pay in the registry, things like that, while I appeal it.
All right. Thank you, sir. Mr. Dukes, get the proposed judgment to Mr. Townsend.
Yes,
Hold on.
yes, Sean.
Mr. Richard, do you have an email address?
Yeah, where would I go to make his payment at?
Do you have an email address from Mr. Richards?
I do, Your Honor. He's when he files his stuff, he has an email address and he's emailed me,
Okay,
so
good.
I can submit the proposed order and copy him on it as well.
Yes.
I submitted
please
to Mr.
copy
Townsend.
on the proposed order, and we'll get it entered and go from there. And Mr. Richards, if you're right, and the Court of Appeals agrees with you, it'll come back to me and I'll do whatever the Court of Appeals tells me to do.
Well, once I paid in that registry, Your Honor, because even that registry, when you talk about like 800, it wasn't even supposed to be that. But that registry, I just gonna pay what I can pay as long as I'm making payment in there. You know.
If you don't pay the full amount that I've ordered, the $800 a month, then your appeal is going to be dismissed.
My appeal gonna be dismissed. But Your Honor, this is right. My check ain't even that enough. Okay, my check is not enough. So I could pay what I can pay in that registry, you know, because my check is not enough. For real.
And
My
Your
check-
Honor, may my client and I be excused?
Yes, you may be excused. Mr. Richards, you may be excused, and
Thank you,
thank
Your Honor.
you, witness,
Thank you,
for appearing here this morning.
Thank you.
All right.
Your Honor. Your Honor. Can you hear me?
Yes, I can hear you.
You know, I'm gonna pay what I can pay in that registry. I heard what you're saying, but it's up to the court.
Mr.
to de-
Richards, you've heard my order, and you can't renegotiate the order. Either you pay what I've ordered, or you're going to be evicted, and you're going to be evicted sooner rather than later. And that's just the way it is. I wish that we could accommodate you, but I have to follow the law.
Oh, why didn't let it be at 600? Because that's the first charge you were charging me. Why was it 600 instead of
All right,
800?
Mr. Richards, the time for argument is over. That's my ruling. I'm going to send you back. I'm going to send you back out. You can leave the call. All right. So we're still waiting on our. Well, let me see if I can join and see how they're doing. We've got Dynasty Mir in the waiting room. Yep. So let me see if this judgment's already been entered against Dynasty Mir. So let's go ahead and admit. Good morning, Mr. Amir.
Good morning, sir. How are you?
I'm doing just fine. Mr. Mir, you're a little bit late.
I am. I apologize. No excuses. Well, no excuses.
So the case was here for trial. In your case, you had filed an answer and a counterclaim. When I called the case and you didn't appear, your answer was struck, and so was your counterclaim, and a judgment was entered against you.
Okay.
Not that they requested on the amount of the credit card debt. So they are going to submit to me a proposed judgment. Once that judgment is entered, you will have some legal option. You have 30 days to try to appeal it. I can't advise you as to what the grounds would be to appeal or what your chances of success or failure are on that, but that's just where we go next from here.
Okay. Can I request a trial by jury?
It's too late for that because you didn't appear at the calendar.
Okay.
Oh, that's where we are. So look for, you've been keeping track of the case online. Just be on the lookout for the proposed judgment, and then your clock will start ticking on an appeal.
Okay. Out of curiosity, when was my okay, well, when was I actually called to I guess?
You were called, well, the calendar started at 10 o'clock a.m. and I called, the calendar was initially called right at 10 o'clock a.m. And then once the calendar was called, probably about 10 or 15 minutes into that, I came to that case specifically. Capital One Bank's attorney answered, you weren't there. They moved for default, which I granted. And then they actually took about 5 or 10 minutes proving up their damages. And then I granted them judgment.
Okay. I was having issues with, I was just having issues with the Odyssey side as far as pulling up the information as far as the Zoom. That's why, so I ended up calling in to your assistant and she sent the link. So that was, okay.
You have some legal options. You have the option to appeal. You can, sometimes folks exercise some other post-judgment options. I can't advise you as to what these are.
Okay.
You may wish to seek legal counsel.
All right, no problem. All right, thank you, sir.